Well, welcome to another episode of National Divorce Talk Raw with your host, Mark Ruiz-Evans. Today, we're going to talk about the recently leaked decision by the Supreme Court to overturn Roe v. Wade and how it might mean that the Supreme Court could change the law regarding secession to make it even more legal for California to secede from America. We'll get right into that. I know it's a big, bold statement. We're going to walk you through in detail the SCOTUS decision, other precedent decisions that they had made, other commentary by legal scholars on their overturning of precedent and what it means and how they could all end up with, they may overturn Texas versus White and say you can secede whenever you want, simply because the court believes that it's a stronger reasoning. We'll get to that and I'll explain it all in just a minute. Okay, well, today's episode is all about the landmark possible overturning of Roe v. Wade, the leaked decision by the Supreme Court that came out recently, and what it all means. Well, let's dive right into it. It's going to be a little technical, but I promise we will show you the evidence to back up this big, bold statement that we're making here. Oops. Okay, so I just need to make sure that's showing. This is the Supreme Court draft decision, and we will get to that in a second. These are the key quotes that I want to cover with you. Now, these are quotes from the Supreme Court case. I will show you in a second, but this is where the text is larger and it's easier to notice what they're saying. Versus in the actual document, it's kind of that 1800s text binding. So I just wanted you to see the key text here. Page 3, but the opinion concluded that stare decisis, which called for prior decisions to be followed in most instances, required adherence to what it called Roe's central holding, that a state may not constitutionally protect fetal life before viability, even if that holding was wrong. So watch that. Stare decisis is important, even if the holding was wrong. Page 5, we hold that Roe and Casey must be overturned. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. That provision has been held to guarantee some rights that are not mentioned in the Constitution. But any such right must be deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. The right to abortion does not fall within this category, that it's deeply rooted in the nation's history and tradition, and that it is implicit in the concept of liberty. They're saying that Roe v. Wade, in their opinion, does not do these two things. So they don't like the reasoning of Roe v. Wade because Roe v. Wade doesn't do these two things in their opinion. And they just got done saying, we don't need to follow stare decisis, which is followed in most instances, if the conclusion or holding was wrong. Page 5 to 6, stare decisis, the doctrine on which Casey's controlling opinion was based, does not compel unending adherence to Roe's abuse of judicial authority. Roe was egregiously wrong from the start. Its reasoning was exceptionally weak. That's important to remember, page 5 to 6. Page 8. The controlling opinion in Casey reaffirmed Roe's central holding based solely on the doctrine of stare decisis, but as we will explain, proper application of stare decisis required an assessment of the strengths of the grounds on which Roe was based. So they're saying you cannot use legal precedent as a reason to uphold the law if the grounds on which that decision was made were not good. Proper application of stare decisis required an assessment of the strength of the grounds on which Roe was based. Page 48, the quality of the reasoning under our precedents, the quality of the reasoning in a prior case has an important bearing on whether it should be reconsidered. So let me show you now. Those are the key quotes. Now I'm going to show you the actual legal decision. Oh, probably need to share screen. This will make sense in a second. Just bear with me. And as always, we show you the actual data so you can look it up for yourself. Okay, so here is the Supreme Court decision. Justice Alito, this is the leaked draft that came out from the Supreme Court decision on Roe v. Wade, etc. There it is. There's all the certification you can see. And I'm just going to re-show you those quotes so that you can see they're actually in here. But the opinion concluded that stare decisis, which called for prior decisions to be followed in most instances, required adherence to what it called Roe's central holding. That's on page 3. Just showed you that. Here you go. This is page 5. Stare decisis, the doctrine on which Casey's controlling opinion was based, does not compel unending adherence to Roe's abuse of judicial authority. Roe was egregiously wrong from the start, page 6. This is page 8. Skipping over that question, the controlling opinion, Casey reaffirmed Roe's central holding based solely on the doctrine of stare decisis, based solely on the doctrine of stare decisis. And then they go, proper application of stare decisis is equals the strength of the grounds. Okay, so that's page 8. Hold on. Might have to skip ahead. Whoops. 41. They're talking about the quality of the reasoning. Under our precedents, the quality of the reasoning in a prior case has an important bearing on whether it should be reconsidered. Page 41. This is page 42. The weakness in Roe's reasonings are well known. Page 50, all in all, Roe's reasoning was exceedingly weak, and the academic commentators, including those who agreed with the decision as matters of policy, were unsparing in their criticism. And so that's the key point I need you to get. The Supreme Court is saying that they can overturn Roe v. Wade because the reasoning for Roe v. Wade was weak. It wasn't very well reasoned. And so while the standard in American law is that when something has been made law for a long time, it becomes legal precedent. And if it's been there for so long, you kind of just keep it. That's why lawyers go to school to study case law. You become a lawyer by studying cases so that you know what the legal precedent of the law is, so that when you go to defend a client or argue against another client, you know, is this a law? Did they violate the law or did they uphold the law? And so you have to actually know the laws. The laws are all based upon previously decided cases. And so they say this list of all the decided cases in American history equals stare decisis. It's the Latin term meaning basically cases decided before or what you have to follow on. So you can't go into a court and say, well, I just think puppies should be called cats. You have to base that on a previous decision. In 1864, the Supreme Court ruled that puppies could be considered cats. You know, you have to have something based upon that. You can't just make it up. So the Supreme Court is saying we can overturn precedent if the reasoning for that law was weak. So we don't care that something's been a law for 60 years. And yes, most of the American legal system is based upon legal precedent, stare decisis, meaning if it's been a law for a while, you keep that law going out. We don't have to do that, is what the Supreme Court recently said. We don't have to follow stare decisis if we don't want to. Yes, stare decisis and legal precedent is basically the basis for all American law. It's the basis for how things are done in America. It's basically the basis for all court cases. But on occasion, if we don't want to follow stare decisis, we don't have to. And the reason that we say that we don't want to follow stare decisis is if the reasoning is weak. So if we, the Supreme Court, look at any court case and decide that it was argued based upon weak reasoning, we can just undo it and overturn precedent, and that's how we see fairness. That's what the Supreme Court is saying. That's why I showed you all those quotes, so that you saw exactly what they're saying in the court case. We don't think the reasoning's strong enough. We can just overturn precedent, and it means nothing to us, even though that's the basis for all American law. That's what the court's saying. Okay, a couple more things for you to see. So the Supreme Court said that they were going to overturn Roe v. Wade because the reasoning was weak. In 1990, this is from the Constitution Daily National Constitution Center, a short list of overturned Supreme Court decisions, May 3rd, 2022 by Scott Bombay. So here you go. In 1992, an opinion from 3 justices in the Casey decision reinforced the role of stare decisis or precedent in the court's proceedings. After considering the fundamental constitutional questions resolved by Roe, principles of institutional integrity, and the rule of stare decisis, we are led to conclude this: the essential holdings of Roe v. Wade should be retained and once again reaffirmed, wrote Sandra Day O'Connor, Anthony Kennedy, and David Souter. So Roe v. Wade was upheld in 1992 because of stare decisis. The judges in 1992 said, we're going to keep Roe as the law of the land because it's been the law of the land for so long. It's basically legal precedent. We've been doing it that way. So therefore, because it's been done this way for so long, we're going to keep going that way. That's what they're saying, that they're making this decision based upon the rule of stare decisis. Hey, everybody, we're going to keep Roe v. Wade around because it's already been the law for so long. And the Supreme Court is saying, well, we don't care if it's been the law for so long. If we don't like the reasoning, we'll undo it. So the Supreme Court now of today, here in 2022, is directly contradicting the Supreme Court of 1992. So the 90 Supreme Court said, we believe in stare decisis. If it's been there for a while, you keep it. This new Supreme Court is saying, we don't care about stare decisis at all. If the reasoning wasn't strong, we don't care. So now let's get to this. Just to back this up. So the Supreme Court overturned another legal precedent 2 years ago. Roe v. Wade isn't the first legal precedent that's been established part of American law that the Supreme Court has overturned. They did that this year in 2022, but in 2019, when they first came in, they also overturned a 40-year-old legal precedent decision. Roe v. Wade was largely decided in late 70s, so about 50 years ago, and it was overturned by the Supreme Court recently. This decision has been law for about 40 years and was overturned. So Roe v. Wade was about 50 years of established law that they overturned, but 2 years ago, the Supreme Court undid established law that had been in the books for 40 years. So not as bad as Roe, but still pretty bad. And that is deeply disturbing decision for other landmark cases, say the experts. So Supreme Court overturned a 40-year precedent on Monday, and legal experts said this did not bode well for the future of other established cases like Roe v. Wade. So the Supreme Court is overturning precedent in 2019, 2 years ago, and you already have people saying, wow, if they can overturn that precedent that's been around for 40 years, maybe they can overturn the 50-year precedent of Roe v. Wade. Today's decision is deeply disturbing because it made clear that 5 justices on the court are not faithful to the principle of stare decisis and are willing to abandon precedent when necessary to reach a desired outcome in a case. This raises grave questions about the court's willingness to respect other precedents like Roe v. Wade. So, on Monday, 5 conservative justices broke with the long-standing 1979 decision on Nevada versus Hall, permitting a sovereign state to be sued in another state's court without consent. Clarence Thomas, who wrote the majority opinion, argued that the original ruling went against state immunity in the Constitution. So Clarence Thomas is saying, yes, I know this law has been this way since 1979, or basically as long as Roe v. Wade, but we're going to overturn this understanding of the law because we believe that that original understanding was wrong. That original understanding went against state immunity outlined in the Constitution. So Supreme Court justices in 2019, basically same group in 2022, were saying we can overturn a court case that's been precedent for this long because we don't agree with the reasoning. The reasoning that they used for Nevada versus Hall in 1979 went against our understanding of state immunity outlined in the Constitution. So if we don't like the reasoning, we can ignore stare decisis and overturn this. So here's the court saying, we don't like the reasoning of Nevada versus Hall in 1979. And so therefore, because we don't like the reasoning and we think it wasn't good reasoning, we can overturn it. They said that in 2019. And that's literally what I showed you here, where they were saying, if we don't like the reasoning, we can overturn it. So the court was saying this 2 years ago. And people were going, wow, if you're willing to overturn stare decisis, maybe you'll come for Roe v. Wade. They were talking about that 2 years ago. People freaked out when Roe v. Wade was overturned recently. They were worried reasonably about it being overturned 2 years ago. Nobody did anything. Here we go. Though Harvard law professor Lawrence Tribe argued that while Breyer was right to challenge the majority's reasoning in this decision, he wouldn't lightly assume that the Chief Justice, for instance, would be as willing to overrule the abortion precedents as he was willing to upend the interstate sovereignty immunity precedent set by Nevada versus Hall. So here's a very well-respected lawyer and professor of law, Lawrence Tribe, saying, yeah, I know they overturned precedent that's been around for basically the 1970s. But come on, guys, Roe v. Wade is pretty much established. They'll never overturn that. Lawrence Tribe, a well-respected professor and scholar of the law, was dead wrong. He was saying, Roe v. Wade's so established, they'll never overturn that. Well, they just did. And so that's the point I want you to get. The Supreme Court said in 2019, we will not follow legal precedent if we don't like the reasoning. And we don't care that the law's been on the books since the late 70s. We didn't like the reasoning, so we'll just undo it. And we don't care that stare decisis or following previous court cases is the way most of America operates. We will refuse to follow stare decisis. That is radically different than what previous courts had said. You know, if it was established law, you should keep it as law. That's basically the way most things work in America. Yes, things are overturned. Obviously, slavery was legal at one point and then was overturned. So there are some good cases where precedent is overturned, but not in a while. And this court case, this court was saying in 2019, we will overturn any law, regardless of precedent, if we don't like the reasoning. And then in 2022, we literally saw where in the court case overturning Roe v. Wade, they said we're overturning this precedent because we don't think the original reasoning was strong. Basically, the point is that the Supreme Court now has overturned 2 cases that are massively precedential. Hall versus Nevada and Roe v. Wade. And they've overturned them. Both those cases basically were decided in the late 70s. They've been an essential part of American law for 40 to 50 years, or basically the last 2 generations. And this Supreme Court said, we'll just overturn them if we feel like it, because we didn't like the original reasoning. And so I needed you to understand that they've already done that with 2 different cases. And they've already said that's how they view things, and they will likely continue to do that. What that means is that when we look at long-term decisions like the legality of secession, you could say, well, that's legal precedent since 1866 or 1865. You can't secede. Well, what if the Supreme Court now says, we don't want to follow stare decisis on secession. We think Abraham Lincoln's reasoning was wrong, and Abraham Lincoln's reasoning was weak. So therefore, we don't have to follow it. And that's the question I want you to think about for yourself. What what if the Supreme Court says Lincoln's reasoning What if the Supreme Court says Lincoln's reasoning on secession was weak? They could do that. And you can't stop them, and there's nothing you can do about it, basically. So tomorrow the Supreme Court could go, we kind of feel that the reasoning that secession can't happen based upon Lincoln was pretty weak, and we don't really buy that. They could do that. I'm showing you how they just did that twice in a row. They took two laws that everybody thought were permanent, and they overdid them because they said that reasoning they used 50 years ago, we don't agree with, and so we're just going to overturn it, and we don't care what anybody thinks about that. That's what they said. And the reason this is possible is that they could do this to Lincoln is, take a look at this. So this is from the National Park Service. Lincoln on secession opposed secession for these four reasons. This is Lincoln's argumentation of why secession is illegal, okay? So this is Lincoln's argument on why secession is illegal. Physically, the states can't separate. They're just too close together. He said it's not possible for them to separate because they're so close to each other. That's an opinion. Secession is unlawful. That's also an opinion. There were many people at the time who thought secession was legal. And as we showed you in another episode recently, even I believe it was Cornell Law said it was not clear if secession was legal or illegal according to just the Constitution and the legal documents they had available in 1860. Lincoln decided that it was unlawful, but you can't find in the Constitution where it says you can't secede. You also can't find in the Constitution where it says you can secede. So the Constitution and the law makes no statement on secession. If you can do it, if you can't do it, it says nothing. Lincoln just decided, well, I think it's illegal. But you had people at that time like Clay and Calhoun, who were equally as strong constitutional scholars, had been around during the founding of all these documents and said that the law said you could secede. So it was really Lincoln's opinion that the law was there and that you couldn't secede. The other thing is that Lincoln is the precedent. Presidents enact the laws. They do not make the laws, and they do not interpret the laws. The Supreme Court interprets the laws. The Congress makes the laws. The president executes the laws. That's why the president's post is called the executive, and Congress is called the legislative, and the Supreme Court is called the judicial. So the president is not supposed to be making determinations of the law, period. Secondly, it doesn't say secession is legal or illegal in the Constitution. And even if you believe secession was totally illegal, you had scholars at the time who were well worth their note saying, it's not clear. But Lincoln said, physically, the states can't separate because they're too close together. Secession is clearly unlawful, and a government that allows secession will disintegrate into anarchy, and Americans are not enemies and friends. And one of his other reasons was that if they allowed secession, then the world's only existing democracy would fall and would prove for all time, and to future Americans and to the world, that a government of the people cannot survive. What if the Supreme Court says these aren't good enough reasons? Hey, Abraham Lincoln, we don't believe that states today can't physically separate because they're so close to each other. There's trade unions, there's international airlines. States can separate from each other and be part of separate legal regimes. And so we don't believe that your reasoning that applied in 1860 still applies in the year 2020, given the massive updates in transportation that we have made. They could say that. Hey, Lincoln, we don't think you could say that secession is unlawful. You could say that it's unclear, but you said it's unlawful, and that's not in the Constitution. And so we can strike that down easily because it's not in the Constitution. The Constitution doesn't say secession is illegal. It also doesn't say it's legal. So you can't say what it says because it doesn't say either. They could easily strike that down. Third, a government that allows secession will disintegrate into anarchy. So what? That's not a legal argument. The Constitution doesn't say the federal government can do whatever it wants as long in order to prevent anarchy. That's not there. Nor is there a provision in the Declaration of Independence, the Treaty of Paris, or the Constitution that says the federal government can do whatever it wants to keep a cohesive union and order. That's not there. So this statement, a government that allows secession will disintegrate into anarchy, has no legal reasoning behind it. That's just something Lincoln said, so they could easily strike that out. Americans should not be enemies but friends. Based on what? That's another just esoteric spiritual understanding. In fact, all three of these. Hey, you can't secede because our government will turn into anarchy. Where does it say that that's a concern? Hey, you can't secede because Americans are supposed to get along. Where does it say that in the Constitution, the Declaration of Independence, or the Bill of Rights, or the Treaty of Paris, or that those are things enforceable by law? Hey, we demand everyone in America be buddies, and it is the government's right to force all Americans to be friends. Is that anywhere in the law? No. Secession, if it allowed, would destroy the world's only thriving democracy, and that would be bad for the planet. Why is that a concern of the American people or the American government? So I could easily see these 5 reasons being attacked. And especially this one. So here is Lincoln, National Park Service. Here's where secession is unlawful. This is where Lincoln said it, and then they go, oh, well, this means that secession is unlawful. So in his first inaugural address on March 4th, 1861, Lincoln said, I hold that in contemplation of universal law and the Constitution and the University of these States, Union States perpetual, and it follows that no state upon its own mission can lawfully get out of the Union. In contemplation of universal law and of the Constitution, and that the Union of these States is perpetual. So because his understanding of the law in general and the Constitution is that these Union of States is perpetual, then therefore in his interpretation, no one can leave. So there is no statement anywhere in American law or anywhere in the Constitution or Declaration of Independence or the Bill of Rights or the Treaty of Paris or any of the amendments that says you can't secede or that you can secede. It's literally not there anywhere. So Lincoln's saying, I view the Constitution and law in general as saying America is perpetual. And I view the statement that America is perpetual to mean, therefore, secession's illegal, even though I can't point to any place in the law that secession is illegal. So that's what Lincoln is saying. I can't point to any place in the law that says secession is illegal, but my general understanding of the law and my general understanding of the Constitution says that the states must be perpetual. And if that's true, then therefore I interpret it to mean you can't leave the Union. I interpret it to mean, in my opinion, that you can't leave the Union. That is the executive acting like the judiciary, not constitutional, easily could be struck down by the Supreme Court. Let's take another look. First inaugural address, March 4th, 1861, we find the proposition that in legal contemplation, the Union is perpetual, confirmed by the history of the Union itself. So the Union is perpetual because when I read the history of America, that's how it seems to me. So this is Abraham Lincoln becoming a historian and saying, my view of American history is that the Union is perpetual. Here's a problem. The Articles of Confederation were blown apart. So if the Union was perpetual, then the Articles of Confederation should have stayed. The Articles of Confederation was the original agreement that brought all these states together. They fully pulled out of that and then turned to the Constitution. So if the Union is perpetual, how could they get out of the Articles of Confederation? You shouldn't be able to. It's perpetual. You should modify those articles, but you can't leave. They all left, which means you can leave a union, which is directly disagreeing with what Lincoln's saying. And additionally, here's Lincoln's interpretation is that in my history, in my interpretation of history, the Union is perpetual. And in my interpretation of the law and the Constitution, the Union is perpetual. And in my interpretation of history, the Union is perpetual. That's all your opinion. You interpret history and you interpret a general understanding of the law and the Constitution while no specific law can be cited as meaning the Union is perpetual. And then you interpret that as meaning, therefore, no one can secede. There's a lot of legal interpretations that the executive is not supposed to make and that the Supreme Court could strike down as weak reasoning. Message to Congress in special session July 4th, 1861. The states have their status in the Union. They have no other legal status. If they break from this, they can do so against the law and by revolution. So Lincoln is saying the states don't exist outside of the Union. There's the Union, and the states only exist because of the Union. Well, that's wrong. So if you look at the Treaty of Paris, which was the document that actually brought America into existence, it wasn't the Declaration of Independence, it wasn't the Constitution, it was called the Treaty of Paris, and that was the thing where England stopped fighting and officially recognized America as a country along with France. You cannot be a country until you have recognition of recognized nations. The Treaty of Paris is what allowed America to be recognized by England and France. And in the Treaty of Paris, each state signs the document. There is no one signatory. They mention all the states. Here, I'll just show you. You'll almost never hear about this term. Treaty of Paris between the American colonies, signed between the American colonies and the Great Britain into the American Revolution. His Britannic Majesty acknowledges that the said United States, viz. New Hampshire, blah, 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 Georgia to be free, sovereign, and independent states. So it does not say we view these states as one independent state. It says we view these states as independent states. Independent states, plural. Multiple states, independent. Multiple states listed right before they say independent states, plural. That's actually in the Treaty of Paris, the actual document that made America into the Revolution and formally recognized the United States as an independent nation by England and France. This is what made America America. In the actual literal document, the transcript, we can see where they refer to them as independent states. That directly contradicts what Lincoln is saying. The states have their status in the Union and they have no other legal status. Well, England, when signing the agreement of the Treaty of Paris with the French, completely disagreed with Lincoln. And so that's another reason his arguments could be struck down by the Supreme Court. And here we go. Just to add this up, Huffman said Lincoln believed the legal mandate to keep the country together went back past the Constitution to the Articles of Confederation. That means it's not part of the law. So when you made the Constitution, you got rid of the Articles of Confederation. You can't then use the Articles of Confederation, which you have disregarded and thrown in the trash, as a basis for your law when you created a Constitution that's supposed to be the new basis. That's another weak argumentation of what Lincoln was saying, proving that Lincoln's argument was weak. Oh, I'm looking at the Articles of Confederation. Bro, the law we use is the Constitution, not the Articles. You can't do that. Southern states said they believed they had a right to secede. Lincoln's view prevailed on the battlefield. Since then, it has also prevailed in the courts. So because Lincoln won a war, everybody went with his legal understanding. That's also a weak legal reasoning. And the person who said this, Huffman said, he was pointing at the Articles of Constitution and that the only reason this is legal is because there was a war that was won. Not that two sides went to the Supreme Court, argued their cases, and dispassionately the Supreme Court looked at it and said, oh, secession's legal or secession's illegal. No, somebody shot down everybody who disagreed with them. And then the court said, I guess since everybody who disagrees is dead, you win. That could easily be struck down by the court. And just so you know, Helfman, who said these things here, this is the article, Was Civil War Unconstitutional? By Will Doran, a PolitiFact. So Helfman, who told them that, is this person, Tara Helfman. She is an associate professor at Syracuse University College of Law, where she teaches constitutional history. She also studied and graduated from Yale Law School. So she kind of knows what she's talking about. And that points to there you go. Have been sent legal. Lincoln believed the legal mandate to keep the country together would pass the Articles of Confederation. That's a legal argument that could be struck down. And Lincoln's view prevailed on the battlefield, so therefore he prevails in the courts. That's also another legal argument that could be struck down. So I think I walked you through how the Supreme Court has overturned precedent in 2019, overturned precedent in 2022. Everybody's focused on Roe v. Wade, but really this is part of a long chain of they just overturn precedents in America because if they feel the reasoning is weak, they can undo it, and they don't care about the history of legal precedent. That's what they've said in 2019 and in 2022. And I just showed you how when we look over Lincoln's reasoning for why secession was illegal, there are many holes that could be pointed into it. Enough for a Supreme Court to overturn on state. As a side note, this idea was not mine. Someone, one of our followers, brought this idea to me and said I should do a show on this. Thank you very much for the suggestion. So the idea for the show was not mine. It came from somebody who asked to not be named. So let's take a look at comments. Arian, love you too. California could be a safe country for investment and immigration in the future, as well as one of Iran's friends, and now the independent free country will have it bright. Yeah. California builds bridges while Americans build walls. That's what Jerry Brown said. We don't support terrorism. We don't support intrigue in other nations' affairs. We don't support the disenfranchisement of minorities. At the same time, Californians believe in dialogue and building bridges, and Americans believe in building walls. Thank you. I hope you enjoyed today's show.